Hi, this is Joe Gailey, and I want to welcome you to this final webcast on the subject, your business and your employees. What are your obligations? This installment is going to be how to defend yourself from employee claims. Without any doubt, the best way to defend yourself is to have each and every employee sign an arbitration agreement. Well, you ask, what is an arbitration agreement? An arbitration agreement is an agreement between the employer and the employee whereby the employee gives up their right to sue and instead agrees to submit the issue to a private company for determination. You'll probably say, oh, we can do that? That's legal? And yes, it's legal. The U.S. Supreme Court has ruled in multiple cases that arbitration agreements in employment are legal. However, they cannot be one-sided. You cannot have an arbitration agreement that provides that the employee pay all the cost of the arbitration and the employee put up money up front to do it. The courts will treat that as being unconscionable and will not enforce it. In order to have an enforceable arbitration agreement, the employer needs to pay all cost of the arbitration. But even doing that, because the arbitration, you're submitting it to one person and not to a judge, and it's not a full-fledged court trial, your attorney fees are considerably less than they would be in a courtroom-style litigation setting. Furthermore, having an arbitration agreement minimizes your risk of being sued. All of us see lawyers advertising on television, and one of the classes of clients that they are trying to find are dissatisfied employees. Once they find that you have to go to arbitration, it's very likely that they will not want to do that because the amount of time they spend on the arbitration compared to the fee that may get awarded will not justify that means. They can make far more money going to court and getting fee awards through the federal judge as opposed to through the arbitrator. So arbitration agreements are particularly good if they're written by someone with knowledge who knows how to construct an arbitration agreement. The second thing that you need to do to protect yourself is very simple. Document things and keep them digitally. If you document information, internal investigations, employee personnel files, if you document those things, but you can't find them when you need them, they're worthless. So we recommend that you document all of these things we've talked about, personnel files, internal investigations, employee discipline, and that you keep them digitally so they can't get lost. Thirdly, you need adequate job descriptions and an adequate handbook, employee handbook. How can you prove that you have a policy forbidding something if it's not in writing? And if it's not acknowledged by the employee that I've read and understand this. So to do that, employee handbooks have a double side to them. You can't just buy an employee handbook off the internet and use it. You're going to be bound by whatever that employee handbook says, and you really need somebody knowledgeable, an HR professional or a lawyer, to look at that and revise it and tweak it to make sure that it accomplishes what you want it to accomplish. The next thing you need to do to protect yourself is to have access to a knowledgeable HR person. Now, that doesn't mean you have to hire an HR person. Perhaps your business is big enough to justify that, and if so, that would be wise. But if not, if your business is too small to justify the hiring of a HR person, there are many qualified HR people who will provide telephone assistance to you and provide information and advice as needed. For instance, you might be able to sign a contract with an HR professional for as little as $200 a month that would entitle you to an hour or maybe even 2 hours worth of telephone consultations or actual appointment times to discuss employee problems and employee issues that come up. And this would be a great way to start revising your business and looking at how to gear yourself and protect yourself from employee claims. And finally, bring an attorney in early. If there's a problem that comes up, don't wait until it becomes a large problem to bring in your attorney. Bring in a knowledgeable attorney early in the process and let he or she get involved in trying to keep this thing from getting as big as it can be, because if it gets as big as it can be, it's not going to go well for your business. It's going to cost money to defend. Even if you win, you're going to lose. Well, this concludes our webcast series on employees and business. We hope that you've enjoyed it and learned a lot from it. This is a very complicated subject, as you can probably tell after having viewed all these webcasts. And as a result, you certainly need some specialized assistance for your particular facts and circumstances. But hopefully you've learned enough from this series of webcasts that you will be able to at least understand and inquire and discuss knowledgeably the issues involved in all these things. Thank you for tuning in.